Florida Supreme Court is now in session. Please be seated.
Thank you. We'll now take up case number 2022-1553, Cox versus State of Florida.
May it please the court, counsel. Robert Pierce on behalf of Mr. Cox, we've requested 5 minutes of rebuttal time. Well, good morning. This capital appeal stems from Mr. Cox's conviction in 1998 for the murder of a fellow inmate at Lake Correctional Institution, and his most recent penalty phase in 2022 after being granted Hurst relief in 2017. Now, we've raised 7 points in the initial brief, but for the purposes of today's discussion, I'll be focusing just on the first 3. The first 2 of these are very similar. They both stem from the court's sentencing order and involve the court's rejection of a total of 3 non-statutory mitigating factors, 1 for not being proven, and 2 for being, in the court's view, not mitigating on the facts of the case. For these 2 points, we're seeking the relatively limited remedy of a remand for the court to consider what we contend are the erroneously rejected mitigating factors and to conduct a reweighing accordingly. And for point 3, which involves unobjected to comments in closing argument, we're seeking the more substantial remedy of a remand for a new penalty phase. Regarding point 1, which dealt with the mitigator relating to Mr. Cox's dementia, the court, despite the state conceding that this was proven in their sentencing memo below, and despite the court acknowledging the expert testimony that the defendant has dementia, nevertheless rejected it as unproven. And it did so under the rationale that, quote, there is no evidence that Mr. Cox suffers from the early signs of progressive dementia. But there's 2 problems with this. First, the mitigator itself didn't limit itself to progressive dementia. So the question of whether it was static or progressive dementia isn't dispositive of whether this mitigator was actually proven. And second of all, there was actually evidence of progressive dementia. Dr. Rabino testified that he could, progressive dementia, by the way, is just something like Alzheimer's disease, whereas static is something that is caused by an event, like a traumatic brain injury. Dr. Rabino testified...
Doesn't the mitigator suggest progressive dementia, though, when it says early signs of dementia, versus a static dementia that seems to be more limited in time, and then you're looking at the effects from that? Go ahead.
My read of the mitigator is that the early signs of dementia is just referring to his age, that because the testimony was establishing that this condition was occurring, the atrophy in his brain resulted in him being older, or results that indicated an older gentleman. So like someone who has the same results someone should be expected to do better on this even at age 80 than he's doing it at age 59. So I've read that as relating to the age, but even in the event that the court reads it that way, it still doesn't fix the problem that there was evidence of progressive dementia, because as Dr. Rubino testified, his testing puts him in a range where he could really have Alzheimer's disease. Quoting, he's definitely in a range where he could also be suffering from early Alzheimer's disease. He has significant risk factors for Alzheimer's disease. His testing has gotten worse over the years, and his testing puts into a range where if he were a Parkinson's patient, he would not be allowed to say that he could have consent to surgery.
And I've looked at all that testimony, but if you look at it all in context, it looks like he's equivocal about it. I mean, and I think that's what the trial court found, isn't it?
Respectfully, I'd have to disagree, Your Honor. I think the testimony...
You don't think the trial court found that?
That the court, that he found
that it was equivocal?
Whatever. Oh, yes. No, that was exactly his rationale.
But again, part of this is, I understand there are different ways to look at these things, but the trial court is the trial court, and unless it's unreasonable and there's not evidence to support what the trial court does, we go with the trial court.
I agree.
And this, what you had just said about the way this was pled, not indicating that it was about progressive dementia, I hear you, but it seems like to me the opposite reading of that is more persuasive. I just don't understand why it would be phrased the way it was if it was talking about anything other than. Now, I heard what you said, but it seems to me eminently reasonable for the trial court to interpret the way it was pled the way the trial court did interpret it. But so tell me why I'm wrong.
Well, no, I won't. I think that is a reasonable interpretation of that language. I'm not going to say that the trial court was unreasonable for interpreting it that way. However, I don't think that fixes the problem that there was evidence of progressive dementia, because his testing, as Dr. Rabino testified, puts him in the range where he could also be suffering from Alzheimer's disease. So the court's rationale for rejecting this was that there's no evidence of progressive dementia, but in fact there was. And so even if we disregard.
Did I hear you say the word could?
Pardon?
Did I hear you say the word could in what you just said? He could be suffering from Alzheimer's?
Yes, Your Honor. The testing range.
Could doesn't cut it. I mean, you have to prove these mitigators.
Well, if we're going off of a reasonable reading of the language of the submitted mitigator, it's early signs of dementia, which I believe the signs of dementia kind of lessen that strict threshold that you're suggesting. But
so is your argument, and I want to just make sure that we have the argument right, that the trial court abused its discretion in rejecting it versus failing to address it? Because the initial brief talks about it as a failure to address, which requires a remand to address it. And I think what you're arguing today is the trial court abused its discretion in rejecting the evidence.
The argument specifically is that the court did not have a rational basis for rejecting the unrebutted expert testimony establishing dementia.
Okay.
So
so that's not really a failure to address argument.
No. And this is what distinguishes it. This will come up in the second point relating to Gill, but it's not about a failure to address. It's about the kind of the procedural posture of this evidence before the court and whether or not its decision to find it either unproven or in the later points not mitigating on the facts of the case was rational. So I'll move on to point 2, which deals with the mitigator relating to Mr. Cox's impulse control. Now, in rejecting this mitigator, the court acknowledged that Mr. Cox has suffered from impulse control issues throughout his life, but still concluded that it was not mitigating on the facts of this case because the actions leading up to the murder, in the court's view, show that he could control his impulses. But there's 2 problems with this rationale. The first is that it's treating this condition, this diminished capacity for impulse control, as though it's an all or nothing thing, as though it's a condition that's either acting up on a certain day or it's not. But even in the court's sentencing order, it acknowledges that this is a diminished capacity thing. This is a relative capacity to a normal person to control their impulses. The court, as I said, acknowledges this in their sentencing order, and this is what differentiates this case from Gill, which is what the state relies on to support the court's rejection of this. Because in Gill, we have almost exactly the same thing, where the court finds that a very similar set of evidence establishing a brain condition that causes diminished capacity for impulse control. But in Gill, and unlike the instant case, the court actually gave that some weight. And so I think it kind of shows the problem here, because while the court would have been free to assign it some non-zero amount of weight, there's not a rational basis to reject it as not mitigating at all.
Well, it was the trial court accepted testimony of an expert in reaching the conclusion, right? Dr. Lazaro?
Well, I think the state's position, in the sentencing order, he did not rely on that testimony. And I think the state pointed this out in their answer brief. So the court's rationale was based purely on his view of the defendant's ability, whether he could control his impulses that day or not. I don't think it was based off of Dr. Lazaru's testimony, but even if it was, the problem with Dr. Lazaru's testimony is that it doesn't actually address the root of this mitigator, because the root of it is the damage to the portions of Mr. Cox's brain that affect impulse control and the resulting diminished capacity to control those impulses from that damage. So it's not about whether or not whether the murder, as Dr. Lazaru testified, whether or not it was an impulsive murder, whether or not you could categorize it as something impulsive. The mitigator is about his relative inability to a normal person to control those impulses. And so again, the court was free to assign it a lesser amount of weight, but what it couldn't do is reject it as not mitigating at all, because again, this is like a relative diminished capacity.
Counsel, why isn't, let's assume that we accept your premise, why isn't it just harmless? Because it seems like the court considered 19 other mitigators, right, some of which overlapped with that dementia diagnosis, some sort of cognitive issues. So why isn't it just harmless?
Well, I think that's a good question. I want to distinguish 2 things. That one, that portion of what else he considered for dementia is not related to this point about impulse control. And importantly, in the sentencing order, the only mention of impulse control is on this point, outside of the statutory mitigators, which he rejected. The impulse control is only mentioned in addressing this specific non-statutory mitigator. the question of why this isn't harmless, while it's the state's burden to prove this, I think there's three very good reasons why why the error can't be considered harmless. First, it's the heart of the defense. This was both the defenses, the heart of the defense for both mitigation and in challenging CCP, which the jury rejected. It goes two of the most important things before the sentencer, which is the moral blameworthiness for the offense and the prior violent felony aggravator, because this mitigator was submitted as being ameliorative of both the offense itself and the prior violent felony aggravator. And it's clear from the sentencing order, or at least from the rationale in the sentencing order, that the reason for rejecting it is based purely on the offense. So the court did not address whether it would be ameliorative of the prior violent felony, which is the weightiest of the two aggravators in front of it. And so because it's going to the central question before the sentencer in any capital case about the moral blameworthiness for the offense, because it's also going to the weightiest aggravator there, and finally, because in the defense's view, it's our position that this presents at least a case where the decision of death could not have easily been reached, given, as I was mentioning, the lack of CCP and EHAC, and the fact that there's the two remaining aggravators that were found overlap to a decent degree, given that he was in prison for his prior violent felony, or he was in prison because of his prior violent felony. Because of that, I think those three things combine to meet the relatively low threshold for harmless error, which is just a reasonable possibility of a lesser sentence if the court were to consider this mitigator.
It seems hard, though, to see how you could say that that a reasonable judge could give it slight or little weight, but then it seems like it would be just a completely sort of empty, kind of formalistic exercise for us to say, you have to deem this a mitigator, but if you want to say it's obviously someone who thought it wasn't mitigating at all is not going to turn around and give it, great weight. They're just going to stick a different, a slight or little label on it, and then we're going to end up in the same place.
Well, I would hope that they wouldn't just go back and rubber stamp their previous decision without reconsidering the aggravators and mitigating circumstances.
And I don't mean that in a pejorative sense, but if they believe that it's just not mitigating, but we say, well, you have to deem it at least somewhat mitigating, then if you assume that, it's the same thought process by a person who did their job and was thoughtful and whatever, it seems hard to believe they would give it anything other than slight weight.
Well, I don't think that, I think the problem with this is, and let me clarify one point earlier. When I said the court could have assigned it some amount of weight but couldn't have, a very little amount of weight, but couldn't have assigned it zero, I wasn't suggesting that this is a mitigator that's worthy of little weight. In my view, it's worthy of a significant amount of weight. And I think the reason why the reasonable likelihood of a lesser sentence exists is because the court did not consider, appears to not have fully considered the ameliorative nature of it, specifically because he's rejecting it as he's not appreciating the relative nature of it, despite acknowledging it in the sentencing order, and I think equally as importantly, never addressed the ameliorative nature of it related to the most weighty aggravator before it. So because from our perspective in this posture, we're looking and saying, well, there is at least a reasonable likelihood. It appears that the court did not consider this based on the sentencing order, based on the rationale we were given. And so the question is just, is this sufficient enough to create that reasonable likelihood of a lesser sentence? And I think its locus with the central question before the sentencer clears that bar, I think, by a significant margin, because we have not only just the close case, but the fact that this is going to the question before the sentencer on such an important decision about whether to impose the death penalty or not. Lastly, I want to close just by making a couple points regarding the fundamental error in closing arguments. Now, the standard for this is whether or not the comments were so prejudicial as to taint the jury's recommended sentence. Obviously, there weren't any objections to these below. The state has commendably conceded that the comments relating to justice were improper, but have contested the other two types of errors that we've challenged. One of them, I'll refer to as just the easy way out comments. They point out that similar comments were held improper by Irvin, but in Brady, and I think they're correctly pointing out that in Brady, this court rejected similar easy way out comments because the prosecutor did not also accompany them by misadvising the jury regarding duty to come back with a sentence of death. And it's true that the prosecutor did not do that here. That's not what I'm challenging. But I think it's important to distinguish that he did tie those easy way out comments to a different type of improper comment, which was justice for the victim. And so... But
when we look at both of these comments, they're both kind of, he makes them at the beginning of the closing argument, very long closing argument, and it ends with this emphasis on the law and the facts and that this life sentence wasn't sufficient to deter him in the past, so why would it be sufficient to deter him now? When you have these kind of isolated comments at the beginning, why if we're looking at fundamental error, do we place the significance of that over the entirety of the closing that occurred after?
Well, I think it's clear that that fundamental error is clearly viewed, you clearly view the closing arguments as a whole, and I see I'm eating into my rebuttal time. So no, I think you have to look at closing arguments as a whole, and see everything in context. The problem with these particular errors are that they are using the weight of the state to pressure or at least invite the jury to reach their ultimate decision based on a reason other than weighing the aggravating factors against the mitigating factors. And so that's why we believe it amounts to fundamental error.
Isn't typically when we reverse on fundamental error in a closing argument situation, it kind of pervades the closing argument, and it's the sense that the jury is left with. Like, it's not this kind of isolated statement at the beginning. It's really runs throughout, and it is the emphasis of the closing argument.
Typically, yes, I believe that the trend for these cases has been to have a collection of, a lot of improper closing arguments and then tying them all together and saying these cumulatively amount to fundamental error. I think the problem is that effectively this gives the state a free pass to make these improper arguments regarding justice for the victim that have been held improper since the first Reagan administration.
Well, if it's objected, it becomes a different analysis if it's objected to.
It certainly becomes harmless error at that point. I think the problem here is just the indelible nature of the prejudice from these comments and inviting the jury on such an important decision to make a decision about the death penalty for reasons other than the aggravators and the mitigators. So with that,
can I ask you a question about the commendable concession?
Yes.
Isn't this? I know that our court has said without any kind of reasoning backing it up, they've questioned these justice comments, and they usually talk about the impropriety in terms of, improperly trying to elicit sympathy for the victims and everything, but just without kind of surrounding sort of emotional appeals. I don't know why talking about justice would be improper when it seems like this whole exercise is basically about justice.
My first thought is the language from Cardona v. State, where it talks about how the cloak of the state's authority, when a prosecutor is standing there with the cloak of the state's authority, it gives them the ability with a minimal amount of words to create a significant prejudice and impact on the jury. And I think by making these appeals to anything outside of the central question, the only question before the jury, which is relating to the aggravators and mitigators, I think once we stray from that and start bringing in concepts like justice, especially
but isn't
justice
the whole point?
for the
I mean, when the defendant is up there, trying to establish mitigators and arguing it, aren't they basically kind of saying, given this kind of mix of circumstances, it would be unjust to execute my client or me? I mean, isn't that really what this is all for?
Well, I don't think they're arguing for justice in these cases. I think they're arguing for mercy, and I think they're fundamentally different concepts. And I don't think those, similar comments from the defense, don't carry with them the same kind of prejudice that, again, speaking with the state's authority to a lay jury about how justice is impacting their decision. I think it invites it's the kind of impropriety that shouldn't be guiding cases, especially in a death case. So with that, I'll reserve the remainder of my time.
May it please the court, Assistant Attorney General Stephen Ake on behalf of the state of Florida. As to the first issue, I would submit that the court properly denied the non-statutory mitigator that appellant suffers from the early signs of dementia. Dr. Rubino was asked on, I believe it's page 767 of the record, for his diagnosis in this case, and he started a laundry list of the various things that he diagnosed the appellant with, and dementia was not listed as one of those. The defense attorney then questioned him as to his neurocognitive disorder, if dementia would be included in that, and he said it probably could be. Again, not equivocal diagnosis of that condition. He testified, Dr. Rabino, that the results of the Montreal cognitive assessment test that he gave the appellant put him in the range of it. Again, he did not diagnose him. He just said his test scores were consistent with that. Based on that evidence, I believe the trial judge acted within his discretion in rejecting that non-statutory mitigator based on that testimony that it was not established by the greater weight of the evidence. But even if this court were to find that the trial judge erred, the court did find numerous other non-statutory mitigators related to appellant's cognitive functioning that I would submit would make any error harmless, because he found brain damage, he found deficits in his executive control, numerous ones related to his alcohol and drug use and its effects on his brain, brain injuries and all that. I don't believe that a medical diagnosis of dementia or even progressive dementia, which again Dr. Rabino said he couldn't diagnose him with, I don't think that would have changed the sentencing calculus in this case whatsoever, and the judge still would have sentenced him to death even if he had found that. So I don't think there's any error in that first issue. On the second complaint that appellant has about the mitigation, which deals with the second one, which is the
Impulse control.
excuse me?
Impulse control.
Yeah, the impulse control thing. Yeah, I was thinking it was the sine qua non thing, but no, the impulse control. What happened here is the trial judge based his rejection of this mitigator. He found that he had established that he had impulse controls throughout his life, but given the facts of this case and Dr. Lazaro's testimony that this was not an impulsive murder, the trial judge was justified in finding or in rejecting that mitigation. This court has upheld other instances where courts have found that a rejection of impulse control is proper given the facts of the murder. And in this case, we have the defendant planning it out a day in advance, announcing his intention to the entire prison pod that he was housed with, and saying that he's going to give a reward. He then gets information about who may have broken into his locker and stolen his money, and he basically orders a shank from another prisoner, conceals that, waits till the next day at lunchtime when he realizes that there will be less correctional officers in the prison yard while they're at the cafeteria, and he calls over the victim and begins to pummel him. Now, Alan Cox outweighed the victim in this case by about 100 pounds, and by all the accounts, he did this beating in front of numerous inmates and had the victim in the fetal position begging for help, and he said, "That's not good enough, I'm gonna," then he reaches into his pocket and stabs him 3 times. That 24-hour or thereabout 24-hour passage of time shows that this is not an impulsive murder, and the trial court properly rejected that mitigation. Again, even if this court were to find that it was error, I would submit that it would be harmless, because as Chief Justice pointed out, you would, I guess, remand it back to the trial judge for him to find and weigh that, and I'm sure he would not give it more than very little weight or slight weight or what have you, but that's not going to change his ultimate sentence in this case, given the strong aggravation that was present in this case in the mitigation. As to the other issue that counsel talked about were the closing arguments by the prosecutor that were not objected to. Obviously, it has to rise to fundamental error, and the state would submit that really what we're boiling down to, he raises 2 little paragraphs that the prosecutor discussed, and the first one, I don't see anything wrong with that comment whatsoever. Really, the only issue is the prosecutor saying that, is this justice for the victim? And that's a very innocuous single comment that he made early on in his closing argument. It's not near as egregious as a number of cases that this court has discussed that comment in. I don't think it rises to the level of fundamental error for sure. There's no way that the jury, that single comment is going to affect the jury's recommendation in this case. So the state would submit that appellant has not shown any error in this case, and that this court should affirm the sentence. If there are no further questions, I'll rely on my brief for the remaining issues. Thank you.
Thank you.
Just one final point regarding the harm in point 2. The the court's rejection of this is not mitigating. The problem with it is that it ends up running afoul of Eddings and Lockett, of the court not listening to the mitigation. And I think the question simply, if this court agrees that the impulse control mitigator that it was error to reject it as non-mitigating, is just simply whether this mitigator, which again goes to the heart of the defense, it goes to the question of both.
Does it go any more to the heart of the defense than the other mitigators that the court did in fact find that are sort of sung in the same key?
I wouldn't say they're in the same key, just because, again, the only
they go to his mental status, they go to his brain injury, for example, right? Like, that's the court finds it and gives it the weight it does. Help me understand what I'm missing, because it seems to me like that is before the court has acknowledged it, and if it finds that this other mitigator isn't established, it still has this other basis that was weighed by the court in determining its ultimate sentence.
I think the impulse control mitigator is fundamentally different from the others, and the court's reasoning for rejecting it rests on the idea that it's an all or nothing thing, and it seems clear from that rationale that the court did not appreciate the nature of this mitigator, given that it's affecting his diminished capacity. It's not an all or nothing thing.
But the brain injury is the same. I guess that I'm not hearing really an answer to my question.
I apologize. The injury here is, or the mitigator here is going to the injury that is affecting the portion of his brain that is affecting his ability to control his impulses. He has a diminished capacity relative to a normal person to control those impulses, and that the mitigator was submitted as being ameliorative of both his inability to control his impulses and commit the offense, and of his prior violent felony offenses. So even if this court rejects it as being unrelated to the current offense, it wouldn't fix the problem in the sentencing order of the court not considering the ameliorative nature of it related to the weightiest aggravator before it, which is the prior violent felony. So, with that, I request this court reverse for either reconsideration of the aggravators and mitigators or remand for any penalty phase. Thank you.
Thank you very much. We're adjourned.